Hello friends, I hope you are all doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today, we will discuss the acknowledgement of legitimacy under Muslim law. Let's start with an introduction first. The Muslim law recognizes the institution of ikrar or acknowledgement. Acknowledgement is the recognition of paternity or maternity of a child. A family consists of husband, wife, and children. Where there is no dispute regarding the marriage of the spouses and the children are living along with the parents, it is generally presumed that the children are legitimate. The problem, however, arises when the marriage of the spouses is in dispute. Since Muslim law is very strict about legitimacy of children, a spouse is not entitled to recognize the paternity or maternity of an illegitimate child by way of acknowledgement. In Muslim jurisprudence, the legitimacy of a child is determined by the date of conception and not by the date of birth. A child born during the marriage of its parents will be considered illegitimate if its birth was prior to the marriage. The doctrine of acknowledgement is an integral part of Muslim law. In India, Muslim law of acknowledgement receives full recognition. There are several cases where this doctrine has been recognized by Indian courts. The leading case on this point is Muhammad Allahabad Khan versus Muhammad Ismail Khan, decided in 1888. Though it's an old case, it's a landmark case on the point. This judgment was delivered by Justice Mahmood of Allahabad High Court. It was held that doctrine of acknowledgement is part of the substantive Muslim law of inheritance and not a mere rule of evidence. An acknowledgement may be made expressly by the father. Similarly, a father can very well acknowledge paternity impliedly. For example, if a child is born to its mother before the expiry of 6 lunar months from the date of her marriage with its begetter, while the law will ordinarily regard it as illegitimate, the begetter may acknowledge it as his legitimate child. His acknowledgement amounting to an implied affirmation that to others he and the child's mother were married at the time of its conception. In the case of Muhammad Amin versus Vakil Ahmad, AIR 1952, it was held by the Supreme Court that an acknowledgement of paternity can be either express or implied in the conduct of the person concerned. A person may also acknowledge the paternity of the child by way of his conduct. It is, therefore, not necessary for the acknowledger to specifically acknowledge the paternity of the child. The conduct of the acknowledger shall be sufficient for this purpose. It may, however, be noted that an acknowledgement that is casual and not intended to have legal effect can operate as an implied acknowledgement. The intention of the acknowledger must be clear. In the case of Zameen Ali versus Azizu Nisa, AIR 1933, the husband acknowledged the marriage with a particular lady. After his death, it was disputed that the child was not legitimate child of the deceased. It was held that the marriage between a person and the child's mother was approved by the former. Such a statement may be accepted as an acknowledgement of the child's legitimacy. It has been held that a valid acknowledgement is irrevocable. Its subsequent retraction by the acknowledger can have no effect. It has also been held that the doctrine of acknowledgement is applicable only where either the fact of the marriage itself or the exact time of its occurrence is neither proved nor disapproved. In the case of a child who is proved to be the child of a third person, acknowledgement shall carry no force. In this case, it was also said that if the acknowledgement fulfills all the conditions of a valid acknowledgement, the child shall be considered a legitimate child. Acknowledgement can only raise the presumption with respect to the legitimacy of the child. The child is considered the offspring of a lawfully married union only because there is no other better proof that can refute the claim of the acknowledger. In the case of maternity, it is immaterial whether the child is the offspring of a lawful wedlock or an offspring of an unlawful union, that is adultery. Maternity is established in the woman who gives birth to the child, irrespective of the lawfulness of her connection with the begetter. Moving further, let's discuss how paternity is established. For a marriage to be valid, there must be a marriage between the spouses. The marriage may be valid or irregular. The presumption depends on the access of the spouses. If it is proved that they did not have access, the child will not be treated as a legitimate child of the spouses. The paternity of the child is established by the husband of the child's mother, where the child is born not earlier than 6 months after the date of marriage under Sharia law. In the case of termination of marriage, paternity is established if the child is born within 10 months under Sharia law, within 2 years under Hanafi law, and within 4 years under Shafi and Maliki law. Muslim law insists on the existence of a valid marriage between the begetter and the bearer of the child at the time of its conception. A person born in a lawful wedlock is said to be the legitimate child of the spouses. A lawful wedlock here means a proper and regular union. Friends, under Muslim law, legitimacy is a status that results from certain facts. In an old but very pertinent case on this point, Sadiq Hussain versus Hashim Ali decided in 1916 that no statement made by one man that another is son can make that other legitimate. But where no proof of that kind has been given, such a statement or acknowledgement is substantive evidence that the person so acknowledged is the legitimate son of the person who makes the statement, provided his legitimacy be possible. Now, let's discuss the concept of acknowledgement under Section 112 of the Evidence Act and newly enacted Section 116 of the Bharatiya Saksha Adhiniyam 2023 and the Muslim law as a comparison. The provisions of the section provide that the fact that any person was born during the continuance of a valid marriage between his mother and any man or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate child of that man, unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten. The section supersedes Muslim law and it applies to Muslims as well as to others. If Section 112 of the Evidence Act and newly enacted Section 116 of the Bharatiya Saksha Adhiniyam 2023, if this section is applicable to Muslims, it cannot be applicable to any irregular marriage, that is fasid marriage, as such marriage is not valid marriage occurring in this section. Further, let's discuss points of difference between Muslim law, Section 112 of the Indian Evidence Act 1872 and the newly enacted Section 116 of the Bharatiya Saksha Adhiniyam 2023. Firstly, a child born during the first 6 months of the marriage is legitimate under Muslim law unless the father acknowledges it. It is legitimate under the Evidence Act unless the parents had no access to each other at the time when the child could have been begotten. Secondly, a child born after 6 months from the date of marriage but within 280 days of the termination of marriage is conclusively legitimate under either system, subject to proof of non-access to one or the other. Thirdly, a child born between 280 days and 2 years after the termination of marriage is legitimate by the Hanifi sub-school of Sunni law, whereas in the Shafi'i and Maliki sub-schools of Sunni law, the period is 4 years after the termination of marriage. Under the Evidence Act, there is no mention of whether such a child will be legitimate or illegitimate. Thus, Section 112 of the Evidence Act does not affect the presumption of Muslim law after the period of 280 days. But that presumption is rendered weak and almost nugatory by the knowledge of psychological facts that we now possess. The Indian courts have treated the principles of acknowledgement and legitimacy separately. The principle of acknowledgement has been regarded as part of the substantive law of Islam. On the other hand, the principle of legitimacy has been treated as a rule of evidence. Friends, now let's discuss certain conditions that are necessary for the valid acknowledgement of the paternity of the child. It is true that acknowledgement may be either express or implied. However, there are certain conditions for the validity of an acknowledgement. The following are the conditions for the validity of an acknowledgement of paternity and legitimacy. First, difference in age. There must be a reasonable difference in age between the parent and the child. A man cannot establish the relationship of father and son between himself and another unless he is at least 12.5 years old. Second is the capacity of understanding. The person who has acknowledged his act must be able to understand the consequences of his act. It is not necessary on the part of the person who has been acknowledged to give his consent. He may be so minor that he may not be able to understand the relationship. The child acknowledged must not knowingly be the child of another man. It means the child must be of unknown paternity at the place of his birth or at the place where he is residing. Where the parentage is certain and it is known that he is the child of another, he cannot become the child of the acknowledged merely by his acknowledgement. Like Hindu law, Muslim law does not recognize the institution of adoption. Fourthly, it must be legitimate. It is also necessary that the child not be illegitimate at law. To acquire the status of father and child, the child must be offspring of a lawful union. If a child is born on account of an unlawful union, their child will not be treated as legitimate and therefore he will not be entitled to the right of inheritance, etc. A child who is illegitimate at law cannot become legitimate by virtue of begetter's acknowledgement alone. In the case of Niaz Muhammad versus Yusuf Khan, 1934, at the time of begotten of the child, the lady was married to a man other than the acknowledger, and this fact was proved. It was maintained by the court that a person can acknowledge a son where there is no proof of later's legitimacy or illegitimate birth and his paternity is unknown in the sense that no specific person is known to be his father. The court said that a person cannot acknowledge a child who is the offspring of an unlawful connection. It is submitted here that the above opinion of the court cannot be treated as absolute. There are certain qualifications that must be reviewed in light of the facts of a particular case. Fifthly, both Sunni and Shia schools maintain that the acknowledged must believe himself to be the acknowledger's child. or at all events assent to the fact. There is also a condition that the child should also verify the acknowledgement, because the child is considered to be their own master, as the child is supposed to be able to give an account of themselves. Otherwise, if the children cannot explain their own condition, the above rule applies to both male and female children. Next is possibility of matrimonial relationship. For a valid acknowledgement, it is also necessary that the acknowledger and the child's mother be legally able to marry. They should not come within the prohibited degrees of relationships for marriage. It may be noted here that acknowledgement or prolonged cohabitation as husband and wife raises a mere presumption. If it has been proved that there was no marriage at all when the children were begotten, the issue cannot possibly be legitimated by acknowledgement, as decided in the case of Razia Begum versus Sahibzadi Anwar Begum, 1958. Next is the consent of a minor. A minor who is not able to understand things cannot be compelled to give his consent. If any infant is acknowledged and after attaining his majority denies his paternity, such denial is of no effect. Where a child has disclaimed the paternal relationship with the acknowledged, no valid acknowledgement shall take place. Thus, the consent of the minor is not necessary ingredient for a valid acknowledgement. Next point is the capacity. There are certain legal capacities for valid acknowledgement. A person who has been acknowledged must have attained a majority. An acknowledgement made by an infant by a person who is in duress or who is non compos mentis is absolutely invalid. An insane person, however, may be acknowledged without regard to his or her assent in the same way as an infant. Next is acknowledgement must be proved. Mere acknowledgement is not sufficient to establish the relationship. Under Muslim law, an acknowledgement of parentage may be considered analogous in certain of its legal effects to the doctrine of legitimatia per subsequens matrimonium. Next point is the rule of legitimation by acknowledgement. Muslim law gives the father of the child the right to acknowledge the paternity of the child if the child was born within 6 months from the date of her marriage. This acknowledgement may be express or implied. The rule of legitimation depends on the assumption of legitimacy and its establishment by the avoidance of the hypothesis of an unlawful relationship between the parents. Muslim law does not recognize the Western concept of legitimacy, which is the conception of a child outside of wedlock. In the case of Imam Bandi versus Mutsadi, decided in the year 1990, where a man and a woman were living under the same roof. Their living was continuous and it was not casual. By virtue of their union, children were born. The father of the child acknowledged the children as legitimate offspring. Such acknowledgement was held to be valid. It was further held that the acknowledgement shall be treated as valid even though the acknowledged child's mother was originally a prostitute. The important point is that valid marriage was entered into between the spouses. Under Muslim law, marriage with a prostitute is not ipso facto illegal. Next point is the acknowledgement of a child by a married woman. Under the Sunni law, acknowledgement should be made both by the husband and the wife. The acknowledgement only by the wife will not carry any force in the eyes of the law. It is easy to prove the maternity of the child, but it is very difficult to prove the paternity. It may Therefore, we observed that a woman who is married or who is observing iddat or probation cannot acknowledge a child alone. Her acknowledgement must be supported by her husband. Whereas under Shia law, a married woman is fully competent to acknowledge a child, provided her husband does not take any objection to her statement. The difficulties, however, may arise when the husband is dead and the widow is expecting a child. If there is no dispute as to the birth of the child, the parentage would be ascribed to the husband. Next point is the establishment of paternity of the child by DNA test. In the case of Sharik Ahmed versus Sundar Lal in 2008, the application for maintenance was filed by the respondent. A child aged about 5 years through her mother, who claimed therein that he was the legitimate son of the petitioner. The petitioner denied paternity and has pleaded that he is not responsible for the maintenance of the child. The family court, considering the diametrically opposite evidence put forth by the respective parties regarding the paternity of the respondent, has reached the conclusion that the paternity of the child can be decided by a DNA test and accordingly ordered for a DNA test. Keeping in view the principles of law laid down by the Honorable Supreme Court in the case of Amrit Singh versus State of Punjab, 2007, considering the interests of the child aged about 5 years, whose claim for maintenance is denied by the petitioner on the ground that he was not his father, and the fact in issue was the paternity of the child, it can be decided by directing the petitioner and the child to face a DNA test. The court held that there was no illegality or jurisdictional error committed by the family court that may occasion failure of justice or manifest injustice to the petitioner. If the petitioner refuses to face a DNA test, in that situation, a necessary inference may be drawn by the concerned court while appreciating the evidence. Now, we come to the conclusion of today's lecture. We can conclude by saying that acknowledgement of a child may be either express or implied by the conduct. Where a man is openly treating a child as his own, it may be presumed that the former has acknowledged the paternity of the latter. But mere casual acknowledgement of paternity, not intending to confer the status of legitimacy, will not have the effect of conferring that status. There must be an intention to confer that status. So with this, we come to the end of today's lecture. Thank you so much.